Yes, ma'am, you are audible.
Okay, so good evening, everyone. So
Good
today's
evening.
topic is
So Advocate Ghosh, can I just
yeah,
introduce ILA in a
yeah,
minute, and I'll hand it over to Sania ji, and you could then proceed if that's okay. Sure.
yeah, sure.
Yeah. So good evening, everyone. My name is Madhura. I represent
Good evening, everyone.
Indian Lawyers Association.
Good evening.
Just hold on, please. Yeah. The audio and video is clear, right, Sania ji?
Yes, ma'am, it was reverberate. Maybe it was because we were not on mute. Yes, muted there.
Right. Sure. Sure. So good evening. Welcome everyone to today's event hosted by ILA Sonipat chapter, which is on a very interesting and important topic of understanding construction arbitration. We have with us Advocate Biswarup Ghosh, who would share his insights and inputs on this topic. Myself, Madhura from ILA. Allow me to quickly introduce all of us to the Indian Lawyers Association. ILA is a pan-India network of all the legal professionals in the country, and we work to create a common voice of all the lawyers and bring them together on a platform which essentially enables to continue educational growth, provide a networking platform, offer mentorship and guidance to young lawyers, and an important feature of ILA is to promote pro bono and public services by the help of legal profession. So to do this, we operate on a model of having local chapters. So these chapters add in local flavors, and they pick up what's going on in their city and add a lot of vibe, the current local vibe to their operations. So we're happy to have about 75 chapters currently. If the participants here as well as on YouTube see a name of your city in this list, please reach out to us. We would be happy to connect you to your local chapter. And if there is a missing name, your city is not on this list, we'll be still happy to form a new chapter in your city. So with this, I'll hand it over to Sania ji, who is the president of ILA Sonipat, one of our very young and very dynamic chapters of ILA. Sania ji, over to you.
Thank you so much, ma'am. Thanks for introducing ILA. And this event is hosted by ILA Sonipat, which, as Mathura ma'am said, is one of the recently formed chapters of Indian Lawyers Association. And we have been working towards holding online events. So far, we have held events on the topics of intellectual property, events on general topics like justice, reforming justice system, judicial system, etc. And today we are here to discuss a very emerging topic of construction arbitration. And I'm sure all the arbitration enthusiasts, especially students who are interested in the field of alternate dispute resolution, will find this useful and come to know about this new field. With us, we have our speaker, Advocate Biswarup Ghosh, and I have the honor to introduce him. Advocate Ghosh is currently practicing as an advocate in the Kolkata Civil Court, and he has previously served as a project consultant and engineer in EY and is a former FSSM fellow. He's also a certified and licensed building planner and has worked as a building planner at Nirman, Kolkata, and other certain building planning companies. And he also is a registered and chartered civil engineer, and he also has a patent to his name. His technology, autoclave technology to produce fly ash gate, has got patent from the Australian Patenting Institute. And today, and now, sir is working in the field of construction arbitration. He's also working in the field of litigation and advice, mostly in the field of construction and construction-based disputes. With this, I hand over to Advocate Ghosh to introduce himself, his area of expertise, so that we can further take up this conversation today. Over to you, sir.
Thank you, Sania, for introducing me in such a good way, and I am very much pleased to be a part of this ILA team as well as to be a guest speaker in this construction arbitration field. So construction arbitration, it is a very, I mean, uh, very difficult to understand why construction and as well as law is a emerging in nowadays. So construction, there are many reasons where a construction can be causes problematic. So leading, there are disputes related to this thing, construction. There are basic points I am going through. After that, I will go how these disputes leading to the arbitration sector and how these arbitration proceedings and where the arbitration proceedings mainly is going in high scale, in which locations, as well as what are the main challenges is facing in this construction site as well as in arbitration proceeding follow on. So okay, now let us talk about the when the arbitration is arising. Arbitration is arising because there are disputes. So what is the disputes in a construction site can be pointed out by anyone such that we can go for any litigation or mediation process. So first of all is incorrect ground data. As a civil engineer, when I have worked in field, there are a lot many of ground reality and as well as the representation of the reality through the modern technology like MIS, like Excels, like project management tools like Primavera is not done in a proper way, first thing. Second thing, faulty and ambiguous provisions in contract. What is faulty and ambiguous provisions? Suppose in contract it is asked to complete one project within a certain time limit, but which is merely possible in a construction. So this time limit, when it is cutted down, when it is completed, then the contract document is also going to an invalid one. And when this is going to an invalid contract document, then it is cause a litigation, and then litigation causes a dispute, and which a finally comes into a solution to be a dispute solution by dispute resolution process, either in terms of legal way out or in terms of mediation or ADR, whatever maybe you can call it out. And arbitration is a very okay, I will go further. Why arbitration? Why no other any litigation process is not taken such a higher way than that of arbitration proceedings? Next is mainly faulty administration of contract. Faulty administration of contract means administration who are making the contract between the field executors as well as the between the field executors and the authority who is making the contract. Suppose I am giving one example. Suppose today one government body make one contract of making a road and it make it tendered, and the some of the company construction company got the tender. For getting the tender, first of all, they have to provide a time plan to when I and it is called the time plan is provided by in a tender. It's called TOR. Terms of references is there within the contract. So at the time of floating the tender, so we have to follow that TOR to make ourselves eligible to that contract. So when everybody is trying to make themselves eligible such that they get a huge amount of contract, huge amount of reputation and such that things. So whenever they compete in that contract, in that contract tendering process, they eventually win. Suppose a company X company eventually win the contract, but they didn't consider the field realities like the weather conditions, like the public agitations, like the land related issues. In all these points in their consideration, such that they can make the contract to be a physical reality to complete the work. This is a very big challenge in field, as well as in the documentation way out. So in the first point where I am telling that incorrect ground data, so incorrect ground data means this is the thing. When you go for the field work, there are a lot many of lefts and rights are going on. But when you are representing this to the authorities, to the officials, then it is a big distorted due to because of the time lapse, because of the physical problems which you are facing on the ground. So these two are not coming in the same page. So this mainly causes the dispute in field sector. Next, another more thing, sometimes it is found, very rare cases, not in the big contracts, contractor of poor means. Contractor of poor means when the contractors are getting this contract in a, suppose 90% of the government contracts are in a very low rate and with a huge amount of work and within a very stipulated time manner. 90% of government contracts are in this way. So when a only this kind of problem can be sorted with a person who are very much efficient in this, in that field. But sometimes it was found that contractor who has not that much of field knowledge, in order to get that contract, they settle the contract outside the bidding process and get the contract. So eventually what happens, the person get the contract, but the quality of the material, the quality of the construction work, the final product of the construction is not up to the mark which the according to the book or which according to the field was expected during the time of tendering of the project. Next, here is the very big issue where we can call it the primary thing of the dispute, that is levy of compensation for delay and delay in payment of RA bills. So if you want to understand what is delay, then I must say delay is not a one word. Delay is the, like what you can say, like a sea of knowledge. So this only word is leading the arbitration or any kind of construction problem nowadays. Not the quality control, not the faultiness of the contractor, not the administrative problems, nothing is coming into the position, but only the delay is the main point where the contract in nowadays project are getting in a litigated way. So in this way, nowadays a strong steps have been taken. You must have known the name of the authority, that is NHAI, National Highway Authority of India. They have taken a several steps in order to make these things possible, to make this DNA analysis to be minimum, such that the litigation is coming a minimum and the project will be completed within the stipulated time as well as within the stipulated construction technology which I have mentioned in the TOR itself is maintained and all these things. So next is why arbitration. So I will call after the point delay, because I already told delay is like ocean or sea you can ask for in this construction arbitration sector. But first of all, I go for the why the arbitration. There are lot many of ways in terms of legal proceedings what you can go for litigation solution process. So what is the main reason to be go for an arbitration? Arbitration is, first of all, is a quasi judicial process. In this arbitration proceedings, it is not at all directly comes under judicial process, but in another way or in another words you can say it comes under a judicial process. So how how this arbitration process, it is uh, it is easier for us. Because these decisions which are made in this arbitration process is not imposed. It's a solution to make the things easier, to make the litigation to be solvable, such that we can reach a point where the project can be continued and where we come to an end in a very easy as well as earlier manner. And I have mentioning 3 to 4 advantages for this construction arbitration, so that you can understand a easier way why construction arbitration is necessary. First of all, it is a formal and quasi-judicial process, and the decision which is made by an arbitrator is not imposed. It is made between the concession, between the consideration of both the parties. Next, quick a cheaper settlement. Next is best and suited technical solutions. Now the point is coming. What is technical solution? Why it is how this arbitration can be a good technical solution? Cause in most of the way, whoever maybe the advocates are, joined or going to be advocates are joined, they may not be that much of tech. I am not asking for anyone that may not be technically that much of knowledgeable to be a arbitrator in terms of construction point of technical reasons. And the major disadvantage of this arbitration is you have not any right to delegate your arbitration proceedings to any of your subordinates or any of your delegate personnels to take the decisions. Like the court proceedings can ask for a commissioner, court proceedings can ask for a technical experts, maybe ask for a medical expert for different type of litigations or something like that. But in arbitration proceedings, arbitrator will be the sole person who will be taking the decisions, as well as in terms of legal way, as well as in terms of technical way. So the technical way, this point is very crucial. How one LLB advocate or whatever maybe can be a technically solid. For this, you have to learn some construction related courses. Regarding this, you can go for some project management related understanding. Otherwise, this construction arbitration is a huge, huge problematic to be understand. Cause the point which I have raised before, that is delay analysis, that is totally comes under the technical knowledge that is called the project management unit. So project management, these points are come under project management. So you have to learn what is the project management, how the one project can be managed. If you learn how the project is managing, suppose there are 5 kinds of works in a construction project you have to complete. First, you find that you in a construction work, you have to do for some official work in first stage of your starting the work. After the bidding is done, after the work has been delegated, you have to do some field related work as well as the official works to get the work order to be completed, to get the official appointment from the government authorities as well as from the private authorities to get the work done. Next thing, you have to do the field execution. So in the first process, there may be a time lapse, cause in India government works which we are seeing in terms of construction layout, in terms of government point of view, there are much many of, as as madam said, I have already worked as a technical expert to be a to a Ganjam district, so in Odisha. So there I have shown, it was very much easy to understand for me how much legal process you have to go through the government way out in order to get the work done from the table to the field. It's a huge process. You have to go day by day. You have to go day by day. Different personas are there who have to take the decisions, and their decisions may cause a different problems to the field, and that person will be responsible to sort out the problem. So they have to take the decision in a very delicate way. So for this delegation, it is a very much time taking. If you make ki I will complete this work within a period of suppose 2 days ki 3 days, then it is a very big problem. Then your project will be hampered in this way, and your project will be get delayed, and eventually it is called for a it is called for a delay analysis. It will be called for a litigation, and it will be called for a dispute for the which will call for a arbitration eventually. So first of all, in this phase there can be a delay. Next phase, when you go for a first instance of the field execution, then you have to one field is been given to you, and you have to work there. If you go 90% of India government on ownership lands are being litigated. Why so? Because they are of in India, we are a, as we all know, we are a uh, growing country. We are not at all very much of ample quantity of land available within our area, and we are also a farm farming oriented country. So maximum time it is found that people are going acquire knowingly or unknowingly the government land for their own purposes in farming, as well as residing, as well as many other things. So if you go for asking to leave them to a person who are residing a place over more than 7 years, 5 years, 10 years, whatever maybe the time limit is, then that person will cause a litigation. That land litigation has to be sorted out. Sometimes it has sorted out by the government which we are getting from which we are getting the work order. Sometimes it is not sorted out by them. Sometimes we have to go for the legal procedure. And as we all know, legal procedures is a time-taking process. And till when the legal process end to complete the land to be handed over to that person, till then your contract time will be ended up. So again, there is a call of delay. So you have to consider all these kinds of delay, as well as in terms of construction that I have just 2 to 3 minutes back I have mentioned, that is RA bill. So what is RA bill? You have completed, one contractor has completed of some percentage of work. There are different types of contract in our civil engineering construction sector, as mostly it is 10 to 12 days. I don't go into the details into the contract. One is mostly you can take as example as a lump sum contract. So if you go in the contract procedure, so in a contract you will find there are a lot many of clauses, pros and cons you have to maintain in order to do the work in the field. So if one of the pros and cons has not been maintained in the field, then there will be a illegitimate time delay from the authority of passing the RA bill. If the RA bill has not been cleared by the authority who are the owner of the project, then the field work is getting delay, and the contractor is also not completing or using that amount for the next half progress of their project. This is also cause a litigation. In this way, we can also go for arbitration proceedings. So arbitration proceedings is a very easier way to reach out, because there are many way out. You can go for a court proceedings, but in court proceedings is a very long time taking process. You have to file the case, you have to frame the issues, you have to make sure the honorable judge get the understanding of the problem what we are facing in the field, as well as the person who are legally knowledgeable as well as technically knowledgeable. He will file a, I mean, will appointed as a commissioner or receiver to get a detailed report. report of the field which is going on and what the problem is arising. According to the report, where maybe there may be discrepancies, there may be the problematic to understanding. So this is a long time taking process. But in arbitration, it is not a long time taking process. It is a very easy process, very easy to sort it out. First of all, it is done a very mannered as well as structured way to make the easy solutions and to make the quality outcome to solve the problem and further processing in a future works. Now the question is arising, who else are getting the arbitrators in this construction arbitration sector? So construction arbitration is not in one thing. Construction arbitration is differently, it is distinguished by like roadways, railways, PWD, as well as airport, as well as treatment technologies, as well as in different construction sector. No person is that much of knowledgeable enough to adjudicate all the sector at its own. So sometimes we can form a group of 3% or sole arbitrator, or the group of 3% combination of ex-honorable judges of high courts or Supreme Courts, as well as ex-technical experts of some different authorities, like maybe it's railways, then we call for rights, or IRCON, or different government organizations, railways. If we call for roadways, then NHAI, or different government organizations of road constructions, as well as in Airport Authority of India is there for the airport constructions, and port is different port construction authorities are also there. So this kind of personas, along with one ex-honorable judge of either High Court or Supreme Court, or as well as one person who have a proper legal knowledge. These three may be the probable chairs of this kind of litigation process. It may be changeable, it may be variable from time to time, from construction to construction, from department to department, it may be variable. Now the thing is that what the role we can play as a arbitrator. First of all, you have to understand any litigation. When you understand any litigation, any problem, you have to understand the core. What core? You have to understand the core where the problem is arising. For understanding the core, you have to get a basic knowledge of the project. You have to get, as well as one, I should say, being a civil engineer as well as lawyer, I should say a lawyer can play a role of anyone in this working area, because sometimes we can fight for a doctor, then we have to go for the medical details. If we go for construction, then we go for construction technical. If we go for electrical, electronics related problem, cyber related problem, then we go for technology details. So an advocate can do any kind of thing, any kind of person they can be back for. Okay. So, but the main reason and the main point you have to understand, you have to know where the litigation has been created and how the litigation can be solvable, and what are the probable points which you have in order to sort out this litigation. So then only you can adjudicate, or you can go for, or you can call for an person regarding to the construction. As a construction arbitrator, I will say you have to get some knowledge regarding the delay analysis. This is not a correct platform to give the proper understanding of the delay analysis, how it is done and what kind of, it is a huge, I already told, it is a huge thing, and you have to understand, like there are different softwares you have to understand, like Primavera, like MS projects, like Excels, to understand how the project is defined, how is the project is defined, as well as construction project management, as well as a separate thing. Construction project management, there is a very important term you will come into across with regarding this construction project, that is critical path. It is a very important thing in terms of delay analysis, because if you are going on a critical path, suppose I am giving an example to understand the critical path. Suppose you have 5 works to do within a time period of 3 months, and you can do it also within a time period of 1 month if you go for a regular basis activities. If you can go for it within a 1 month, then is 1 month is the critical path, and in 1 month you are not considering any kind of delay can be caused regarding the project to be executed in the field. So if you are going on a critical path, there is no chance of to analyze or to discuss on the delay analysis. So there also a comes the point of litigation. So here are, you have to understand the construction first, how the construction is going on, what is the main issues where the construction can be get delayed. Then only you can understand how the what is the litigation in the construction and how the litigation can be solved. So that is a wind up of construction arbitration. If you can ask for a small, I mean, understanding, this is the small understanding of the construction arbitration. So next I will like to request madam to go any further.
So much, sir, for that detailed introduction to the field of construction arbitration, and explaining to us how expertise, or at least preliminary or as well as advanced knowledge is required in the advanced knowledge in the field of construction is required in order to perform better in the field of construction arbitration, which is generally something most of the law graduates lack. A combination of two disciplines is something which advocates in general find very difficult to achieve. With this, the last, the question that I have from you, sir, and after that, I'll open the floor for question and answer from the audience as well. If you have any questions from the audience side, you could either type it out in the chat box or raise your hand and we could unmute you.
Sorry, I guess your voice is breaking. If you kindly repeat.
Yes, sorry. So I'll open the floor for question and answer to the audience. If anyone has any question, they could raise their
Okay,
hand,
sure.
type it out in the chat box. Meanwhile, I'll start with the one question that, or maybe I'll keep my question for the end, because it's like a more centered on the law students, a question that I have, and we'll take the questions from the audiences first. I see that we have Ms. Vibhuti here with us. Ms. Vibhuti, would you want to go ahead and unmute yourself and ask the question live?
So someone has typed in the chat, kindly give a view on commercial arbitration. Okay, so commercial arbitration is a very different thing from construction arbitration. Commercial arbitration is dependent mainly on the contract signed between two authorities. Like if you are taking a loan from a bank, it is a commercial arbitration. If you are taking, if you are taking a loan from a vehicle for a for a house, then it is a commercial arbitration you can ask for. So as you know, commercial arbitration is not that much difficult, like as well as in construction arbitration, but I will like to answer it. So you have to, first of all, there are 2 to 3 ways you have to start for a commercial arbitration. So first of all, when you are going for a commercial arbitration, you have to make sure the contract to be an end. Contract to be an end means you have to go for a LRN, that is a termination letter, to make the contract between the parties in the which both the commercial sides. You have to make the end. As after that, you can start the proceedings of the commercial arbitration. As well, otherwise you can go for another way out, which is a very common way out in nowadays, which you are having in Calcutta itself. I don't can ask for in all the city or all the state you are falling for. That is, we are going for a section 9 application under the arbitration constitution act of 1996 for the appointing of receiver and to make the vehicles as well as to make the commercial item to be seized or something like that. And after that, we will make the arbitration proceeding to be, and by the court order, we will start the proceedings of the arbitration. So this is the 2 way out of the starting of a commercial arbitration. And there are other many way outs, many problems which can be called for as a commercial arbitration. But that is a very much good thing to start for, to first of all a LRN, that is the termination letter of the contract, then go for the arbitration starting with.
Thank you for taking
I
up that.
guess I answer Mr. Sorry, Swapnil.
Swapnil's question
Anything more?
on commercial arbitration. I hope Mr. Swapnil's question has been answered. And then we will take up the questions from audiences who have raised their hands. Ms. Vibhuti, would you want to go ahead and unmute yourself?
Anyone, whoever, please just go one by one and unmute yourself and speak up.
Yeah, good evening, everyone. Sir,
Good
I have
evening.
a question that if you want to get into arbitration, to become an arbitrator, what are the qualifications and is there any special course that we need to do for that?
For construction arbitration?
No, in general, to become an arbitrator.
In general, to become an arbitrator, so I will like to bring up some of my personal experiences, because my father is practicing 30 years as a sole arbitrator, as in commercial arbitration, which I have explained just now. So in arbitrator, there is no proper, I mean, official so-called process to be an arbitrator. Okay, you have to, as I previously explained, you must have the knowledge, basic knowledge, which you are getting to adjudicate, first thing, and mostly about an experience as an advocate within the district courts, as well as any of the high courts or Supreme Court, whatever of India, whatever may be. And then you have to get approached by the, by the companies as well as the private personnels. Oh, by the way, I want to make one thing very clear. Arbitration is such a proceeding which can be done between 2 persons only. It is not at all by the company and the personnel, it may be with the government and the personnel, it may be anyone where the dispute is lying, that only arbitration proceeding can be started. So it is the first thing. So there is no particular legitimate courses or particular legitimate knowledge which you have must have. There is nothing like that. That the book, that is Arbitration Conciliation Act, is the sole hardcore book of this knowledge. And you have to know, first of all, when you become an arbitrator, you have to understand that you are chairing something. You are in a chair of a tea table judge. Okay, so when you are chairing a judge, you have to act like that. You can't say you don't know anything. So that thing is very, very much problematic, becoming an arbitrator, if you don't understand what you are going to adjudicate. So first get the knowledge what you are going to adjudicate, then you become an arbitrator of that sector in a very easier manner. It may be commercial one, it may be the sole arbitrator, it may be the government appointed arbitrator, whatever may be it. there are different types of arbitrator appointments. So I am not going into details of the arbitrator appointments on this procedure or like that. If you are asking, I will go for.
Thank you so much, sir, and also for shining light onto the very important concept of preparation of list of arbitrators based on their area of expertise as well. Mr. Srinivas, if you would want to go ahead next and unmute yourself.
No, I want to ask ma'am whether I have answered perfectly, or I mean, if you have any other questions regarding that, I want to first clear that thing. Ma'am?
Yes, sir, it's more or less answered. I just want to know that do we need to get ourselves listed with an organization arbitrator, or
So
because how
there
do we
are
get approached to
many
arbitrate?
organization you can listed with. There are many organization you can listed with. That is, one is I can call for, that is CIARB. You can be listed with, but there is no such official guarantee becoming a listed. You can be a proper adjudication forum, but there are but the without becoming listed, you can also get the forum. That's what I want to say. Becoming a listed one, you can get it, but without becoming listed, that also there is a possibility to get the arbitration possibility for it.
Sure,
Okay.
sir. Thank you so much.
Thank you. And Swapnil, I will go next to your question. I think two persons are already hand risen. I think they should be answered first. I have already answered your one question, so I will go bit off than answering before answering. Mr. Srinivas, please, if you kindly.
Yes, this is with regarding to. Yes, you have told that the arbitration tribunal cannot take help from others, right? That's what you are telling the start of the course. Expert.
Yeah, arbitration can take the expert, call for the expert reports, but they cannot delegate, or they cannot give the power to adjudicate to that arbitration to that delegated person. Alligator can ask for an expert report from that person, but they cannot ask that person to be adjudicate, as they have the better knowledge than the arbitrator. They cannot ask that person to adjudicate the matter on behalf of him or behalf of that person, that arbitrator. That's what I want to
Okay,
tell.
I just got confused because anyway, only in the part of jury, the adjudication part will be confined to others, not in any other part. Even in civil courts
Yeah,
also, we don't adjudicate. And coming to the point of constructions,
yeah,
you have referred about RA bills, running account bills. So I
yes, sir.
want to know regarding the limitation in concern with the RA bills, running account bills, and when you see with an invoice-based bills, there is a difference between invoice-based bills and a running account bill. So can you throw a light on the both the aspect, how you differentiate, how you look into when a claim has come down to your table with regard to RA bill, how the
So
limitation
first
will
of
be
all,
calculated, and if the claim comes to you on invoice-based thing, how do you go about that?
so there is a very technical question you have asked for. That is, one is RA bill, and as well as that is one is the invoice based bill. Yeah, there are a very big differences in between these two things. So one, the RA bill is raised, that consists of I mean, that checklist have there have to be some checklist to be complied, on which the RA bill has been raised, and we have to comply whether the checklist has been technically completed by that contractor which he has demanded in that bill, and the invoice and generated on that bill in a proper manner, or not. So we have to adjudicate in that way. I mean, I think I am not that much of giving clarification over it. I mean, if you kindly ask me furthermore, then I can give you a proper answer. If you kindly repeat the question, please, if you don't mind.
This is with regard to MSMED. See, according to MSMED, we have to pay the bills within 45 days that's been raised.
Yeah.
So MSMED councils are giving awards like anything. Even I'm a practicing advocate. I had a scenario that for a bill of 45 lakhs, they have given an interest of 2 crores. So my question is with regarding to the limitation aspect is concerned, when a bill is raised, if it is a running account bill, that's it is on a piecemeal basis, agreed on an agreement that I can understand, basing on the requirements that have been kept forth and in which pro forma the bill has to be supplied with, and the engineer's decision on that. All this comes to a concluded thing. But when it comes to this MSMED, they are harping upon 45 days rule. And the government now is very much serious on MSMED issues. So that's the reason I've asked you, in running account bill, when you are about to consider the point of limitation, what you will consider, and if it is a invoice raised bill, which is not a running account, then what you will consider as a point of limitation for a claim to be adjudicated. It's purely a law question that I have put forth some notes.
Invoice raised bill, actually, I mean, I have not coming through this invoice raised bill. I mean, in my education process till date. So I mean, mostly the coming to me is RA bill on the basis of the RA bill is coming on. So I think
So let me ease the question in a
further backwards.
There will be an RA bills. There will be an RA bill, and there is a final completion bill. FAC, PRAC, PAC will be issued.
Right.
Okay.
Right.
So I'm asking you, when computing these things, FAC, PRAC, PAC, and a RA bill, how do you check into the limitation aspect is concerned? That's what I'm asking you. So I was not clear by saying invoice bill, but it's like a final completion certificate, like you will give now. FAC, PRAC will be releasing.
Yeah. So when the final completion certificate is issued, that means at that time of issuing the final completion certificate, both the engaging authorities as well as the contractor have come to an conclusion that technology and the construction what I have completed that are in a proper manner, and both the part have been satisfied by both of them. Then the final will has been arised. So when the final bill has been arised by the contractor, the final bill has been cleared by the engaging authorities. So then how the litigation point of concern is arising on that point, that is my point of concern. I mean, if the final bill is before the final bill, the site has been verified by both the engaging authorities as well as the contractor who are in the field, who are working in the field. Both have been satisfied. After that, the final bill is arised, whichever is the for the final payment. And if it is a litigated, if the bill is the litigated one, then their bill can be reconsidered by both the parties with the consent of the both the parties. And if there is a litigation in the final bill which they have arised, final bill can be asked for revising. If not, it is revised by the contractor, or if not revised by the personnel, then previously what amount has been disbursed on the different RA bills, that have to be considered. If the RA bills have been cleared the amount in the final bill also, then the final bill is not a legitimate one. But it is if in previous RA bills you have to consider, if the RA bills are already not cleared, in the final bill the amount is added, then I think that is not a litigation one, and then the engaging personnel are fully responsible to pay the amount to the contractor.
Thank you so much, sir, for answering that question. For the paucity of time, I think we can go to the next question. I guess that's from Mr. Zishan Ali. If you would want to go ahead and unmute yourself.
Yeah, hi, sir. Sir, my question to you is, like in the case where the construction is already done or half done, but the construction is done in the land which is not being allotted. Like it is done in some farming land which is not being allotted, and that farming land owners have filed case against the construction company. So what solution can be done in that case?
Being a adjudication point of view, I will ask that is totally illegal. If the land is not allotted to that person, one person cannot start the construction on that litigated or whatever maybe the public property is. Cause if it is a public land, anyone's land, you cannot go and try to start the construction. It is totally fault of the contractor itself. Okay, so
Like we are taking an exception, like
that thing have to be adjudicated. Sorry,
we are taking an exception, like the engineers were not available due to COVID or some other reasons. We are taking an exceptions. So in that case, what should be done?
Hello.
Yeah, am I audible?
You're.
I'm saying we are taking an exception, like suppose the contractor was not available, or the engineer was not available. There was some mistake, and mistakenly it has been done. So in that case, what should be done? What solution should be given?
Then the contractor is not at all. If the who are allocating the work, who are the owners of the project, if they allocating the land or if they're showing the land, this is your land, you have to work for, and which is not officially written or not officially written in the version, then we have to the persons whose area has been started for whose area has been started for construction purposes, that person can make a party to that construction permission giving authority for allocating the land, and that land have to be private land, cannot be cannot be land. It is come under, then it will be another thing it will come under, that is Land and Land Reforms Act. It is not come under arbitration thing, it is come under Land and Land Reforms Act. So in many of the cases when the road constructions and railway constructions are going on, then the construction have to be taken some of the private properties to make sure the construction will be completed in a proper way. For that case, we have to make some mutual understanding between the private personnel and as well as within the government. And if the litigation has been raised between the private personnel as well as in the government personnel, the person can go for the legal processes, and in which they can get the proper solutions.
Thank you so much, sir, for taking.
So I think this will go under legal and Land and Land Reforms Act. This will not come under the arbitration proceedings, because it is a purely land-related problem and issues.
Thank you so much, sir, for also throwing light upon the distinction between how to decide what matter could go for litigation purely and what matters could potentially go for arbitration, by answering Mr. Ali's question. The last question, sir, which we have in the chat box, and also I'll club with it my question as well, which is kind of related with this as well.
With Indian law degree, advocate can appear in any arbitration in any corner of the world. So I ask another question against this question, whether the person who have asked this, you must have go through the Arbitration Conciliation Act. There are two parts in which it is divided. First part is the arbitration conciliation which can be done in India itself, and second part is divided for the international arbitration itself. So yes, within a Indian law degree, you can go for a international arbitration. There are so many of advocates passing from West Bengal, Calcutta, in government law college, private law colleges. They are going Indonesia's UAE for the arbitration proceedings to be sorted. I already previously told that arbitrator, as Madam has asked previously, arbitrators should have the knowledge of the problem he or she are going to adjudicate. It doesn't matter what is his year of experience, what is his area of expertise, what is his, how much he have been experienced with it. But if the person is experienced enough to adjudicate, then anybody, any person with a, in terms of legal terms, that is adult, in terms of legal CRPC, it is called adult, that we have a perfect brain, perfect, normal mentality, can adjudicate in any matter. And moreover, there is not anywhere necessary being an for being an arbitrator. LLB is also not necessary. As I previously told, it is a T-table judge. So the person who have the knowledge of that subject, sometimes you may have asked, you may have seen in terms of construction arbitration and as well as technical arbitration, there are railway has separate board for the processing of adjudication of arbitration. In that arbitration process, only railway, ex-railway senior officials are the adjudicators. They don't have that proper official LLB degree. So anyone, any person who have the sound enough knowledge to adjudicate the matter can be an arbitrator.
Thank you so much, sir. And that's also an advice. With this, we also get an insight into how the students should start preparing if they specifically want to go into the field of arbitration, or pick and choose any other particular subfield in the broad field of arbitration as well. My last question is from you, sir, which is, what advice generally would you give to the students who particularly want to go into the field of construction arbitration? Do you think that a civil engineering degree or other construction degrees are a sine qua non for a construction arbitrator, or can advocates with no background in construction, like advocates who don't have a civil engineering degree, also learn about construction?
Yeah, advocates with not having a civil engineering degree can be a construction arbitration, but that person might not be a construction arbitrator. He can be a appear on behalf of any of the parties, either from the any of the parties who comes to an agreement. They can be as a before the arbitrator. They can appear before the arbitrator. For this, I will suggest you better go through construction project management book. Any of the writer, any of the author, or any particular course. There are many YouTube channels in regarding constructions, regarding construction project management. You can just take it in a casual way. You can go for it, and you can take the knowledge how the construction is going on and how the construction, the litigation in the construction has been arised and how it is can be resolved. So in this way, you can go for it for the construction arbitration process. And another thing I will last want to add, that is practice makes a man perfect. It's a very old proverb, but the thing is that if you don't know, there are a lot many of ways to learn, and if you learn a few, then there only thing which can make you efficient, that is the only thing is practice. If you start practicing with a personals who are adjudicating or who are working in construction arbitration, you will learn gradually and you will work in a further way to get a proper knowledge how to solve the issues, how to get the issues. That one thing you have to understand that Jishan sir has asked just 2 to 3 minutes back. That is a land reforms issue. That is not an arbitration proceedings. That cannot come under arbitration proceedings. So that thing you have to understand what is the basic point, how, where, which disputes, how the dispute is arised, which dispute is arised, and what is the basic solution of the dispute. These three main conditions can throw a litigation to an arbitration. That's I can say as much as this point is concerned.
Thank you so much, sir, for giving us a very detailed insight into the field of arbitration generally, as well as the field of construction arbitration specifically. And I am very sure that the students and other participants who have joined have benefited a lot from this event, and also understood how to go ahead and plan their career in arbitrations, and specifically construction arbitration, if they are planning to do so in future. Thanks a lot again for joining us, sir, for this session at ILA Sonipat. And with this, I would request Madhura ma'am to end the YouTube live session. And if there are no other further questions or queries, we would also end the session with your permission, sir.